Keir Starmer is the UK Prime Minister, and Nnamdi Kanu, being a UK citizen, gives the UK automatic rights to rescue Nnamdi Kanu from the DSS detention because the International Court of Justice has already ruled that the rendition of Nnamdi Kanu from Kenya to Nigeria was illegal, and the Kenyan High Court has also ruled in Nnamdi Kanu's favor that Nnamdi Kanu, while being in Kenya as a UK citizen, was unlawfully detained and secretly transferred to Nigeria in an illegal form. Well, the UK are expected to release Nnamdi Kanu as Nnamdi Kanu is a British citizen, but the IPOB now has sent a message to the UK government and the UK Parliament because the UK has been slow in acting towards the release of Nnamdi Kanu because it now seems that they are working hand in hand with the Nigerian government. Being a UK citizen gives Keir Starmer an automatic right to say, come, Tinubu, release Nnamdi Kanu. But up until now, the UK have been slow in dealings with Nnamdi Kanu. We all expect Nnamdi Kanu to be released by now because the injustice being carried out against Nnamdi Kanu in Nigerian court is out of this world. And Keir Starmer has been slow. Despite various petitions to the UK Parliament that Nnamdi Kanu is being unlawfully detained, Nnamdi Kanu is one of them. Nnamdi Kanu is a UK citizen. A UK citizen is being tried in Nigeria illegally. But Keir Starmer has been slow to give an executive order that, look, Nnamdi Kanu should be released because Nigeria violated international laws. Without wasting much of a time, let's get straight to the message the IPOB has sent to the UK because they have questioned the UK why they are being slow in reacting to Nnamdi Kanu being held unlawfully in Nigeria detention. United Kingdom's complicity in Nigeria's illegal rendition and detention of British citizen Nnamdi Kanu, a judicial and moral indictments. Now I read. The indigenous people of Biafra, IPOB, decry the continued silence and apparent complicity of the United Kingdom's government in the face of Nigeria's gross and well-documented violations of international law, domestic law, and judicial precedents against Nnamdi Kanu, a British citizen and freedom advocate. Nnamdi Kanu was abducted in Kenya in June 2021 in a state-sponsored criminal act of extraordinary rendition and forcibly returned to Nigeria without any extradition proceedings, a flagrant breach of Section 15 of Nigeria's Extradition Acts, Article 12 of 4 of the African Charter on Human and People's Rights, and Article 9 and 14 of the ICCPR, to which both Nigeria and the UK are state parties. What makes the UK's silence especially appalling is that this is not an abstract diplomatic disagreement, but a matter in which the UN Working Group on Arbitrary Detention, Opinion number 25/2022, unequivocally declared Nnamdi Kanu's detention illegal and ordered his immediate release and compensation. This particular line is clearly stating that the UN Working Group in 2022 has already declared Nnamdi Kanu innocent and also declared that Nnamdi Kanu's detention in Nigeria is illegal because even the UN body itself, apart from the UN Working Group, the UN body itself have recognized that a British citizen is being tried in Nigeria in an illegal way, and they declared this, that Nnamdi Kanu should be released, that he has no case to answer. So why is Keir Starmer being slow in acting or declaring that Nnamdi Kanu should be released? Because now it seems all these things now lies in the hands of the UK government, led by Keir Starmer. Let's continue. The Kenyan High Court ruled that his abduction on Kenyan soil was unconstitutional and awarded damages for Kenya's complicity. The Nigerian Court of Appeal, October 2022, held that Mazi Nnamdi Kanu's extraordinary rendition constituted a fundamental violation of Nigerian law, effectively nullifying the proceedings against him. The Federal High Court sitting in Umuahia 2022 awarded him 500 million in damages for the same violations. Three judicial forums in Nigeria, Kenya, and at the UN level have all concluded that Nnamdi Kanu's fundamental rights were trampled. Yet, the UK government, under the pretense of consular ambiguity and dual nationality, has refused to act or even issue a formal condemnation. This is in stark contradiction to its own principled reaction in the Diko Affair 1984, where it condemned Nigeria's attempted rendition of Umaru Diko from the UK in the strongest diplomatic terms. Severed diplomatic ties, threatened legal action for violations of international law and British sovereignty. It is deeply ironic, if not disgraceful, that while Nigeria is abandoning its own Supreme Court precedents, the UK has chosen silence, thus betraying the very principles it once stood for. To add further insult to injury, the alleged offenses for which Mazi Nnamdi Kanu is being persecuted, primarily political broadcasts, were not committed in Nigeria. The applicable Nigerian law, Section 76 of the Terrorism, Prevention and Prohibition Acts 2022, provides that Nigeria courts can only assume jurisdiction where the alleged act is also a crime in the place it was committed. The well-established principles of double criminality. There is no evidence, no allegation that the UK, where these broadcasts were allegedly made, has found them criminal under UK law. Therefore, by Nigerian law, no court in Nigeria has jurisdiction from the outset to put Nnamdi Kanu on trial. This was the message from IPOB to the UK governments and parliaments. Well, the UK should not be biased because it already seems that Nnamdi Kanu's case is being treated in a biased manner. And my message to Keir Starmer, who is the Prime Minister of UK, will be that he should act towards the release of Nnamdi Kanu because Nnamdi Kanu is a British citizen and Nnamdi Kanu has no case to answer. Well, at this point in time, I'm going to allow you guys to know what to feel about this in the comment section below. What do you think about the UK silence on Nnamdi Kanu's case? Do well to like this video, share this video, and hit the subscribe button below for more trending updates.